Hello, my name is Amir Shafaie. I'm the Director of Legal and Economic Programs at the Natural Resource Governance Institute. So for me, the real strength of the guiding principles for durable extractive contracts is that they can serve as a reference document to investors, governments, and other interested stakeholders as to what the evolution of thinking has been around what factors encourage durability of extractive contracts, rather than just the orthodoxy of kind of sanctity of contracts and the protections put in place by international arbitration or bilateral investment treaties. I think this document searches to identify what really encourages contract durability and to embed that into the negotiation process and the contract terms. So that includes things like the adaptability of a fiscal regime to ensure that there's adequate revenues for the government and compensation for investors in different market conditions and some of the latest thinking in that respect. It also includes other elements that are maybe less focused on, such as the transparency and accountability elements that may encourage durability of contracts. In that sense, I think the endorsement of the publication of negotiated contracts in the sector is an important step, not only because it recognizes an emerging global norm also endorsed by other international actors such as the IMF or the ITI, the Extractive Industry Transparency Initiative, but also specifically because it recognizes the role that contract disclosure plays in durability of contracts. And the principles in their guidance specifically raise the idea that by adding contract disclosure, what we're doing is adding an element of ex post accountability to the negotiation process that encourages negotiators on all sides to achieve contractual terms that can withstand public and commercial scrutiny once they are disclosed. I think that's an important element amongst others that governments and investors can look to in the guiding principles in pursuing more durable contractual arrangements. So on innovation in the guiding principles, I think the process was actually one of the most innovative elements in the sense that it really showed what can happen when there's room for multi-stakeholder dialogue amongst even parties that have very different views on the types of issues that were being discussed in the guiding principles. The facilitation by the OECD Development Center, the ultimate ownership of the document by the OECD Development Center allowed for a sort of discussion and progress that wouldn't have otherwise been the case, and ultimately actually proved to be innovative and productive. On the substance, I also think there are important elements. I mentioned contract transparency in the answer to the other question, but on other issues such as stabilization, I think the document has taken steps forward. First by just envisioning a scenario of places where governments can actually attract investment without stabilization, and so in those instances, fiscal stabilization should not be offered. I think that's actually an important, maybe obvious, but still innovative statement. Similarly, the idea that actually the scope and duration of fiscal stabilization should be ideally limited by government only insofar as to cover what is required for an investor, and also that in certain instances actually the investor may be willing to pay a premium for having fiscal stability, which is the approach in certain countries. And finally, I think the approach on legal changes or interpretation changes that are focused on tax avoidance or BEPS issues, and that those should not be viewed as restricted by stabilization clauses is also innovative. And on non-fiscal elements as well, I think it's important that there's a reiteration of what is largely viewed as global good practice of not including environmental, social, human rights, non-fiscal elements in stabilization. But also the document goes further and emphasizes that actually investors should be envisioning that those sorts of changes in law are going to happen given the duration of the contracts that we're dealing with, and also the context in which the investments are being made, and also that the compensation that should be associated for any compliance with those measures shouldn't be outside of the project mechanisms or an additional compensation, but rather using the same project cost mechanisms if there's tax deductibility or cost recovery, insofar as we're dealing with legitimate project-specific expenses. That would be the vehicle for compensation. All of these, I think, are innovative approaches, both in substance and in the process elements.